Hello, everyone. My name is Ken Vercammen, and I'm an attorney in Edison, New Jersey. So, what we like to do is, answer people's questions and at the end. But what we're going to do now is talk a little bit about probate in New Jersey, wills, estate planning, etc. All right. So let's now, the first thing though we kind of got to talk about is what happens if someone does not have a will. Becomes a problem. If someone doesn't have a will, the procedure to distribute assets becomes much more complicated. So let's say there's three kids. That means that each one of the children has to agree upon who's going to be the administrator. Then each one has to sign a renunciation, and then it has to be filed with the surrogate. Sometimes you get one of the kids that says, "No, I'm not going to sign it." Well, if all of the kids won't sign a renunciation, then there has to be a thing called a complaint order show cause filed in the Superior Court. Everyone has to be served. There has to be a hearing in front of the probate judge. So our rule of thumb is anytime you go in front of a judge, plan on spending $3-4 grand, and the cost of a will is substantially less than that. So there's oftentimes zero benefit to not having a will. The procedures become much more complicated. Number two, there's an additional expense because typically, unless everything's going to a spouse, the administrator has to take out a thing called a surety bond and spend the fee. So the fee could be $1,000 a year times as many years as it takes for them to wrap up the estate. Number three, with no will or one that wasn't signed or done properly, because people cheap out and try to do like some fill in the blank form online. State law determines who gets your assets, not you. And more people are saying, listen, I want to decide who's getting my money. There's no reason why I got to treat my kids equally if one of them doesn't help out, doesn't stay involved. Four, if there's minor kids, say a total stranger determine who gets custody, the probate judge. But the most important thing people got to think about is we see all the time that when there's no will or it's not done properly, it often causes aggravation, fights, sometimes lawsuits amongst the family. So when people are grieving, there's a death in the family, they shouldn't be overwhelmed with one more thing. Think about, who do you want to get your assets? Think about who you don't want to get your assets. If there's minor children, minor grandchildren, well, you certainly don't want them to be getting money when they turn 18. What 18, 19-year-olds do anything wise with money? Zero. Boy, if I would have got money when I turned 18, I would have bought a red fast car and spent the rest of it on Seaside. Now also, the program's not about trying to do things, quick. That's why I always warn people about the online documents, because they advertise it's valid in any state, but sometimes valid is not what is best for them. I don't recommend people trying to do their own electrical work. I don't recommend people trying to do their own plumbing work. So I'd say prior to, believe it or not, the preparation of wills and estate planning documents got easier due to COVID. Who would have thought that? Because, prior to, last year, we would insist everyone come into the office and everyone sit down with the attorney, and then everyone take a pen and fill out a form. And then we would have to type everything from scratch and try to read people's handwriting. Well, since COVID, what most attorneys do is they'll email someone a short questionnaire. The people can then type up in the short questionnaire who's executor one, who's executor two, who gets their things. They email it to the attorney. The attorney looks at it. I call everyone back using that hands-free thing on my car. Then after that, we prepare the documents. We email the documents to people. We call them up again, and people have the choice of. Most people prefer to go to a UPS store or a notary on the weekends on their own. Because most attorneys, even if they are notarizing documents now, they're only doing it limited periods of time. Because we also need to have at least two witnesses on the will. And we've also learned how to make things easier because people can pay by credit card online rather than like dropping off check. I mean, we still do that kind of stuff. So let's talk about what's going into the will. So you're typing in who's executor one, who's executor two, and your name. Easy enough. The attorney has to then all beware of conflict of interest, because sometimes we get calls like, mom wants to get a will done. Okay, listen, we know that mom's a little older, she can't type it, but I'm going to need to talk to, mom or dad before I start any document. And before the program, daughter said, listen, dad has some, issues. We need to get power of attorney. Oh, hey, no problem. I need to talk to him. It seems like every Friday late in the afternoon, we get a call from someone. We got to get power of attorney over mom, dad, or Uncle Joe. Okay, when can they talk to us? Well, they can. Well, we can't do the document. So part of doing planning is trying to get things done as soon as possible. Now, what's an executor? Easy thing. The executor is the one that after someone passes away, they take care of the business. They're the representative for the estate, the personal representative. So you want to figure out who's going to be executor one, who's executor two. Typically, someone will make a spouse executor one of the kids number two. In my opinion, you never want to have joint executors, co-executors. It creates problems all the time. Because let's say they could be twins living together, but it means that everything got to be done, both of them got to do. So if it's co-executors, they're going to sell the house. Well, they got to sign a list. Both have to sign a listing with the realtor. Both of them have to sign the initial contract for sale. Then they got to sign the addendum. Then they got to do, sign both sign the deed. Most, if they're co-executors, a lot of the banks say, listen, we want both people to sign the check. So our idea is trying to make it as easy as possible, not more difficult. I'd say, and those are in matters where people get along. A lot of times you get two kids that don't get along, that are co-executors. We had an estate, brother number one would say the sky's blue, and the other one would say, no, the sky's gray. You're stupid. You've always been stupid. So the idea is make things as easy as possible. Now, believe it or not, New Jersey did away with some taxes. Who would have thought that? New Jersey did away with the New Jersey estate tax. There's no longer inheritance tax if it's going to children, grandchildren, spouse, parents, stepchildren. If it's going to brothers or sisters, the first $25,000 is tax-free. If it's going to a bona fide charity, no tax. If it's going to anyone else, it's 15%. Now, the will takes care of your assets that you own upon your passing, but assets that do not have a direct beneficiary. Certain assets pass directly to who's ever listed. So, that's passed by title. So what's an example of that? Well, sometimes a house is owned husband and wife. Well, a will can't change that. Automatically it goes to the surviving spouse. Bank accounts, if it's POD, joint tenancy, payable upon death, automatically goes to the survivor. The will can't change that. Certain assets pass by contract. So think of IRA, 401k, life insurance, annuity, anything that has a direct beneficiary, the will can't change that. If sometimes if you have, assets that you put a kid's name on it, remember, they can legally take the money when you pass. All right. So you're going to then provide the attorney with who's going to be the beneficiaries, and if anyone passes, who gets theirs. We still have people saying, "Oh, I'd like to sit down and go over things," but I will then say, "Okay, Mr. S, you're married, right? Yes. How old's your youngest child? He's 9 years old. Okay. Listen, are you looking to disown your wife or your kids? No, I wanted to take care of them. Good. You don't need to sit down with me. I know what you need, but it's your job to put down for the minors who would be trustee one, who would be trustee two. And sometimes you don't want to have as the trustee of a kid's money someone who is also younger, because they're not usually strong enough to resist. We want, when people have minor kids, sometimes we create what's called a testamentary trust within the will, not a separate trust. It's not funded. Nothing happens until someone passes away. But what that means is you pass away, spouse passes away, the money's held by someone you pick as the trustee. It's not a bank as a trustee. It's a family member, someone you trust, and they can use the money as is appropriate for health, education, support, college, grad school, whatever kind of school. On the other hand, let's say the kid's 20 and drops out of college and goes, college is so difficult. I need to find myself. I want you to, Uncle Al, or I need an advance so I can go on a trip across Europe to find myself. Uncle Al's going to say, no, I'm not taking your parents' money so you can goof off for a while. People, more and more are not leaving everything equally to kids. Last year in one of our matters, client says, do I have to treat all my kids equally? I go, no. Say, what's your concern? He goes, well, one of my one son lives on the West Coast and we don't hear from him much. He goes, well, let me ask you a question. On your birthday, did he get a card or a call? No. On Christmas, did he get a card or a call? No. Mother's Day, did he get a card or a call? No. Well, then why leave this guy anything? Because he's going to be the biggest problem when you pass away, because they're going to be knocking on the door saying, where's my money? Where's my money? Where's my money? Sometimes people say, listen, I'm going to leave it, rather than leaving it to my kids, I'd rather have it put towards my grandkids for college, etc. My own kids have their own house, but there's not enough money that was put away for college. Some people says I want to have it used for my granddaughter's wedding, or it's your call in what you want. It's your money. If someone says I want to leave everything to the Yellow Dog Society, hey, that's like that's your call. Now, some people have what's called specific bequest. Now, what a specific bequest is where you're leaving specific valuable items or money to a specific person. So sometimes someone might say, I want to leave $10,000 each to each of my surviving grandchildren. Okay, that's fine. Sometimes the ladies say, I want my jewelry to go to my granddaughter, because I know if my son's the executor, he's going to bring it to Cash for Gold and say, what do you give me for this junk? Sometimes the men have their autographed Mickey Mantle, baseball, or some men are sportsmen and they have hunting rifles, hunting equipment. They want to have it go to someone in the family that would be able to use it, because it's a firearm, only someone that has the proper firearms ID can have that. So those are specific bequests. Some people leave specific amounts of money to a charity. Now, I believe, anytime money is going to a charity, there has to be a notice to the Attorney General, and then the Attorney General has to approve the accounting at the end. So I've been telling some of these estates, don't leave a percentage to the charity unless you want them almost to get everything. Instead, leave them a chunk of money, because once they get their chunk of money, then the Attorney General is out of the picture. But if someone says, I leave 5% to, Rutgers Foundation or the Piscataway Library Foundation, well, sometimes it takes the Attorney General half a year to review the informal accounting, and until the Attorney General's office approves everything, no one gets any money. You can't say, well, I'm going to give it to the family members. And if the Attorney General's office doesn't do it, then you have to go in front of a judge. Now, we always want to take care of charities and do the right thing, but I bring that up to some people. Let's talk briefly about minor children. Without a will, a total stranger in New Brunswick decides who gets children. That's our probate judge. So there's never one best person to raise your kids, but think who would not be the best person. And because if there's no will, someone who's not the best person can still go to the judge and say, I want to be the person. So a difficult thing with when there's minors is, people go, well, there's no best person. It goes, well, let me ask you a question. Let's say you couldn't come home for the next 2 weeks. Right now, who do you trust the most to watch your kids? Well, I guess my mom. Okay, good. Make her number one. Well, she's getting older. He goes, yeah, but that's the best person right now. You can change your will a year from now, 6 months from now, whenever you want. Now, if anyone's taking notes, write this down. Self-proving will, self-proving will, self-proving will. The old way, the person signs in two witnesses, but then if the person passed away, there had to be a form signed by one of the witnesses saying, yeah, I was a witness there, and I attended the signing. That's my signature, and I watched the person sign. When the law was changed for self-proving will, person signs, two witnesses, then the attorney and notary, then we sign everything again with certain language. So therefore, the surrogate doesn't have to have the family, present information on who the witnesses were. So you always want to have a self-proving will. And I know some of the old-timer law offices didn't do self-proving wills because they didn't have witnesses, or they just didn't want to deal with it. But the reason why I mentioned that, a lot of these cheapy things online are not self-proving wills. And when the person passes away, there has to be, paperwork signed by a witness. Now, if the witness is around, that's good. If the witness is not around, that sometimes creates problems. So if you already have a will done, look, is it a self-proving will, and how old was it? A will typically is valid, 20 years, 30 years, forever. But there's a difference again between what's valid and what is best for someone. Also, make sure that the will has a clause that says no bond required. I mentioned earlier, if there's no will, has to be a bond taken out. If the will does not say no bond required, then again, there has to be a bond, and that creates additional costs in these cheap things. We do ask questions on our personal interview form. Does anyone have special needs, or is receiving SSI or SDD, or is there any reason why someone should not receive money outright? Because if someone's receiving certain governmental benefits, if they get an inheritance, that could disqualify them from their benefits. When the parents who have kids with special needs, they know, okay, listen, we're going to set up a special needs trust. Sometimes, though, you got a kid that's an adult, but they have substance abuse problems, alcohol problems. They're a spendthrift, and they would blow through the money within a year. We handled a probate matter in Somerset County, and the moms set up what's called the testamentary trust and a will for one of the sons that had an alcohol problem. She was smart. The attorney was smart. So when she passed, the guy's ex-wife filed a motion saying, we're asking that monies be taken out of the trust to pay her alimony. And we went in front of the probate judge, and we said, Judge, the law is the law. The reason why we set up testamentary trust is protected from any kind of creditor. And in this instance, alimony, whose person's owed alimony, that's a creditor also. And the judge agreed with us. So again, sometimes we set up testamentary trust for minor kids or kids that just have problems. Also keep in mind, sometimes you have second marriage situations. So sometimes you don't want to give all your money outright to spouse number two with the hope that when they pass, they'll give your family money, because I see all the times that, that gets changed. So there can be what's called a spousal trust, where, second marriage situations, or sometimes we do it, it could be a first marriage, but why leave everything to the spouse if they have their own medical problems, etc., and they might have to go into a nursing home? if a testamentary trust is set up, the spousal trust, that would be protected from Medicaid. So, and one of the reasons why people go to the attorneys is the attorneys that do this, like, sometimes will advise you and say, what about this? What about this? And sometimes, you got people says, well, I never thought about this. So it's all about, preparation. No one would decide Friday morning, you know what, I'm going to start my 2-week vacation now. I don't know where I'm going. No, you plan. Now, a will does not need to be updated if your beneficiaries and your executor remain the same. But keep in mind, our rule of thumb on an executor or the person who's your agent in your power of attorney is, can they get the job done? Can they drive to a bank? Can they drive, when the surrogate's office opens up? Can they walk up a flight of steps? We're not being, anti-senior citizen or anti-people who can't get around. We're being practical. Just like, it wouldn't make sense to have someone who is blind, doesn't speak English, and doesn't live in the US as your primary executor, unless you have no one else on the planet, because there's things that need to be done. Now, my mother-in-law used to call me every other year and says, I want to come in and get a trust done. And I would say, were you watching Susie Orman? And she says, oh, yes. I go, I love Susie Orman. He goes, well, Susie Orman is right if you live in New York, California, Florida, states where probate is very complicated. But New Jersey's a probate easy state. So I usually tell people, when they ask, why do you think you need a trust? New Jersey probate is easy. It's inexpensive. Attorneys usually charge $3-4 grand on a trust. A revocable trust does not protect assets from nursing home. It doesn't protect assets from taxes. If there's a house, then you got to retitle the house to be owned by the trust. And the and part is, if there's a mortgage, a lot of times the mortgage companies, will say no. So, typically there's not a real need to avoid probate in New Jersey. However, if you have real estate in Florida, California, New York, then I recommend you set up a trust where the property is owned by the trust, so that you avoid that horrible Florida or New York probate process. And by the way, some companies provide medical insurance to people. Some companies provide what's called estate planning coverage. So there's a couple companies that are that provide, wills and things. One is called MetLife, another is called ARAG, ARAG. So some of the people that work for Merck have ARAG. Some of the people that work for Johnson & Johnson have ARAG or MetLife. Discuss with your employer, hey, do we have any kind of legal plan? Now, logistically, what happens, at least in our office now, we prepare the documents, we mail them out to people. I call everyone up. If someone wants to come in during business hours, we sign here. More people would rather go to the UPS store now and sign in front of 2 witnesses. A spouse can be witness number 1, but the other witness, it's better off not to be someone. For the person of power of attorney, though, it should not be the witness should not be the person who is the agent. Now, I mentioned a little bit about revocable trust. There's a thing called irrevocable trust. And those are the ones that people use not only to avoid probate, but to protect their assets in the event they have to go into a nursing home. So to do that with an irrevocable trust, the property has to be retitled and owned by the trust. You can't be the trustee. It got to be someone else that controls it. And 5 years got to go by. So that's the, so we tell people the revocable trusts are fairly complicated. That's why the attorneys that do Medicaid planning things usually charge, 4, 5, 6 grand, because they do it right. And oh, by the way, before I talk about powers of attorney, I usually say anyone that attends any of our programs um, we try to help out. We usually charge a $200 consult fee, but if someone attends one of our programs, we waive the $200 consult fee. Some people put off doing their wills, or they goes, "Oh, I want to read up more on this. I want to read up more on this." Because you don't need to read anything. When I had knee surgery, I read nothing about knee surgery. I just asked the doctor, "You've done this before a bunch of times." He goes, "Yes." Having a will done, attorneys typically charge $400, $500, and it's, in a way, it's a bargain because they will do it. They will do it right. Okay, now let's talk about power of attorney. A will takes care of your assets if you pass away. What a power of attorney does is, while you're around, you're giving the power to spouse, a kid, someone you trust, to be able to help you out and pay your bills, handle your finances. So a power of attorney is either effective right away or only upon disability. So it's effective right away. It's called a durable power of attorney. It stays durable even if someone becomes incapacitated. A springing power of attorney only springs into effect if someone becomes disabled. One of my clients last year goes, "Kenny, listen, I'm a carpenter. You're using legal terms on me, springing and durable. Explain to me in carpenter terms about this power of attorney thing." He goes, "Okay, Fred, if it's effective right away, your son can steal all your money because he's your agent. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money. Knowing that, do you trust your son?" He goes, "Oh, I trust my son with my life." Okay, fine. You want to initial the part that says effective right away. A lot of the bunch of years ago, some of these big banks that were out of state were giving people a hard time. They were saying, "Well, it wasn't done on our Wells Fargo form or this or that, and you got to go and get a new one done." Well, a lot of times it was too late. So the legislature came up with a law to say, listen, if it makes reference to New Jersey statute and they do business in New Jersey, they got to honor the New Jersey done power of attorney. No more of this baloney where, oh, it wasn't done on a Wells Fargo form. However, it has to make reference to Section 2 of PL 1991, C95, C46:2B-11. And I'm pretty sure a lot of, these, a lot, we know that these cheap forms online don't make reference to New Jersey statute. Let's see. And we've been revising our powers of attorney every year. So, for example, we added, when the federal HIPAA law came into effect, we added a clause for that it's the person who's our agent also has the ability in the federal HIPAA law. There's a thing, also the ability to make medical decisions under PULSE. Also, the person who would be the designated caregiver pursuant to NJSA 26:2H-5.26. So we revise our statutes, put some of the similar language in our living wills. So the better thing to do is make it effective right away, because if it's effective only upon disability, you're going to have a difficult time having the bank or financial institution honor it, because even once you get a note from a doctor, then they might say, well, how do we know that the person is still disabled? We don't know. It is also a good idea to re-sign your power of attorney every 5 years, because also, again, some of these financial institutions give people a hard time when they're older. We've been sending people the forms as a Word document. That way, they can change their documents down the road. The last document I'm going to talk about is the Living Will Advance Directive. So, people have heard of the Karen Ann Quinlan case, the Terry Chavo case, where someone's in a hospital, coma, irreversible condition. And the Terry Schiavo case was where, went to the United States Supreme Court where, the husband said, listen, the doctors declared her brain dead, remove the tubes. And then the family said, no, 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 we don't want to, do that. So really the document is not for you as a sick person, it's for your family. So the pressure is not put on them to have to make that ultimate decision. I remember one time when I was asked by the doctor, okay, should we remove life support? And I said, geez, doctor, I feel bad. It's like, okay, let's like, the person's going to die today. And, now, the right decision is for someone who's 92 years old, that's not going to ever, open their eyes again. But you hate to be the person. I couldn't even do it for my dog when my dog was like so sick. I had to have my wife go into the vet. So the good thing with the Living Will Advance Directive is, your loved one is sick, whatever, and you just say to the hospital doctor, listen, this is what they did back in 2021. Let's respect their wishes. Oh, and by the way, only the original will can be admitted to probate. A photocopy cannot be admitted to probate by the surrogate. It's a good idea, though, to at least, you might want to make sure that the executor one, executor two knows where the original is at. Sometimes people even give the original to executor one. Regarding the power of attorney, I recommend clients nowadays scan it, send it to agent one, agent two, let them know where the original is at, but also scan and send it to your financial advisor, your bank, your accountant, any place you have money, your life insurance person. Regarding a living will, it's a good idea to scan the living will. And again, you send it to yourself. It's on your phone. Send it to your doctor. I remember one time, with a family member, a doctor said, "Is there a living will?" And I said, "Yes. It's in my emails. I can send it to you." And they said, "Okay, good. One less thing we had to deal with." We have a website, njlaws.com, and there's articles like more information about living wills, answers to probate, etc. But it says, you don't need to read about stuff. Just, contact a professional, have things done. So our next topic is probate, estate administration, et cetera, et cetera. So now we get to bring in like the deputy surrogate of Middlesex County, Heather Antonuccio, nice Irish name. And she's going to tell us a little bit about how, things have changed due to COVID. They might change back, but Heather, it's your turn.
Hi, hello everyone. Hi, I'm Heather Antonuccio, and I am the Deputy Surrogate of Middlesex County, serving under our new surrogate who just won her election, Surrogate Clarabelle Cortez. And our goal is to help the community deal with these terrible matters in a very efficient manner. Unfortunately, since COVID, our office has been closed to the public. We're doing everything by mail, by going online, filling out a form, sending it in. We're sending all the paperwork to be signed in front of a notary and sent back to us. On November 1st, our office opened for in-person appointment only. So it's only like a few a day. But if you would rather come in person to handle the estate, we'll do that. And we are still doing by the mail right now. I can't emphasize Ken enough when he said you do these wills that are homemade. More than half of my Superior Court docket at this time, because I checked today because I knew I was coming tonight, are wills that were homemade and that were not executed properly. So it's just fees and months of problems. So a quick visit with the attorney, get your paperwork in order, figure out who you want to do, who's going to do what you want, who's going to get what you want, and just fill out these forms properly. It's probably 1 in 6 forms that are homemade are improper. So it is so important, like Ken said, to just have everything done by an attorney, somebody who knows what they're doing, because the slightest little mistake could make a big problem for the family, and we hate to see that. We want every estate to go smoothly. We are going to be opening satellite offices in the future. We're thinking in 2022, January, hoping to have a couple satellite offices open as well as our main office.
Oh, Heather, let
We
me
have,
let me talk a little bit about the will signing. Okay.
thank
First
you.
of all, as an attorney, unless I think we're going to do it right, we don't do it at all. And sometimes we also have to be concerned a little bit about undue influence. So we got to make sure it's what that person wants, not what their kids want. And one of the things you're also getting with an attorney, if the attorney does the document and the witnesses, is you get impartial people that don't have any outcome, and the questions asked when the person comes in: did you read it? Does it contain what you want, et cetera, et cetera. When the people do the cheapy things, a lot of times it's they put it under someone's like hand at the hospital and goes, okay, grandpa, sign this. This is so we can help you out. And that's not what it is. It's so they can really be stealing grandpa's estate. Okay, continue. Sorry about that.
That is so true. So many cases. And like you had brought up about the original will. It's so important that the executor knows and has access to the original will, because that's the other half of my superior court cases are probating copies of wills or copies of a codicil. Um, so yeah, that is so important that the executor knows where the original wills are, where the original codicils are. And yeah, the homemade wills, it never goes well.
Now, don't put your original will in a safe deposit box or the documents. Partly because what happened last March and April? You couldn't get to the bank to go get it out. And a lot of times it's all of a sudden, hey, we need to get the living will, power of attorney, on an emergent basis. Well, the bank isn't going to open up for you on a Friday night or a Saturday afternoon or Sunday morning. You got to go and make an appointment, etc. So most people just go to Costco and get a fireproof box. They leave it under their bed where everything collects dust, or the floor of the closet. But fireproof again means you got to close it up. Not have it so filled with like papers that the papers are sticking out.
That's so true. That's so true. Just please, we just beg our whole office just begs everyone, just have your documents in order. It just makes things so much easier. A process that could take a week and a half, if it's done wrong, could take months. So we like the week and a half process. But we are hoping to open soon. We are getting our office is getting updated. So we want to go paperless in the future. So this is huge for us since we've been such a paper dependent office for so long. But with that, we just want to make things easier for our clients. We want to do online appointments. So all these things are in the works, and we're hoping by 2022 that we'll be able to implement these things. Oh, I lost the volume.
If someone doesn't have a will,
Okay. Ooh, if somebody
sometimes I
doesn't
tell
have a
people, don't
will,
believe
that's
what
a
I have to
problem.
say, believe what they have to say. Yeah.
Well, I had a question today from one of my clerks. A woman called, her brother refuses to sign, will not sign her renunciation. So now what happens? Now this poor woman has to put him on notice for 40 days. If he responds and it becomes ugly, then it has to go to court. If not, then she can be appointed as if he doesn't respond, as he was put on notice. However, that never works. The other party always contacts the office. These like deep rooted family issues, when somebody passes away, just explode, and it becomes a ridiculous court matter for months and months. And that, we hate to see that, but we're seeing it more and more when people don't have their estate in order, or their paperwork in order. Administrations can be so much more costly because you have to post a surety bond through an insurance company. And like Mr. Vercammen said, if you don't wrap up the estate in a year, and sometimes you don't, because there's a lot going on in estates, especially with COVID, with the state of New Jersey, if you're paying taxes and things like that, you're going to have to keep paying that premium. So just to make like a will would just be the best option. It's, cost wise and aggravation wise.
Um, someone like, by the way, before COVID, sometimes someone would be in my office at, let's say, 11 o'clock, and they would, oh, we need help with probating the will. It goes, okay, leave my office right now, drive to New Brunswick, park in the deck, walk up the hill. You have the original will, death certificate check for $150, and you will be back in my office by lunchtime. There's no appointment needed. And that's where, as of November 1, we're back to that system.
Mm-hmm. Yes, we can't wait to get back to full in, just open the doors, have everyone come in. We just want to make sure we do it safely and as effectively as we can.
Yeah.
So
okay, so someone comes in the original will, the death certificate check for $150. There's a form they fill out, you type in everything, and then you give them, okay, read this. Is everything correct here? Sign. And then what happens after that?
Then once we have everything in front of us, we're able to issue the certificates. So then the executor is off and running. They can go ahead and start administering the estate. They have everything they need from our office, and they can go ahead and get things done.
Now, surprisingly, I tell people the reason why New Jersey probate is so inexpensive is once you're at the surrogate's office, the surrogate's office has no involvement whatsoever afterwards, unless it goes, there's an issue that has to be brought in front of the judge. You're supposed to file a notice of probate with the surrogate, but if you don't do it, bad, there's no penalty except that it extends the time where someone can challenge the will. In New Jersey, like what logistically, the executor, opens up, obtains a tax ID, opens up an estate account. The attorney helps them prepare an inheritance tax return. There's no inheritance tax, as I mentioned, if it's going to children, but when there's a house, you got to get a tax waiver. You file that with the county clerk's office, you sell the real estate, you transfer assets. And then for most estates at the end, the executor prepares an informal accounting, and I tell the executors, listen, every month or more, send an email to the whole group saying, this is what's up. Because what annoys people almost the most is, I haven't heard from the executor and I don't know what's going on. So I tell people, listen, you send an email every 3 weeks, you have less of a problem. At the end, an informal accounting is done, and the attorney typically prepares what's called a release and refunding bond, and it says, okay, this is what you're getting. Look at this. It's mailed to everyone. They individually have got to sign in front of a notary. But if someone doesn't sign, someone's obstreperous, we typically say, listen, we're not going to give any, people aren't going to get their money until either everyone signs or a judge approves a formal accounting. And sometimes you get the troublemaker brother that, I'm not signing any of that stuff. Yeah, but you won't get your money. Well, I don't care. Okay, then, then we usually send out a letter to all the beneficiaries saying, we received a release and funding bonds from everyone except for, brother X. And because of that, the law in New Jersey says we're not allowed to distribute anyone's money. And if it's not signed, we're going to have to then go in front of a judge, and that's going to delay. And then the surrogate got to do this thing called an audit, and that would possibly delay everyone getting their money 6 months, a year, a year and a half. And then we put in the bottom of the letter, the person who hasn't signed is this person, and we put their phone number and their email. That way the family tries to lean on that person, because otherwise that's what has to be done. What if there's if there's no will and it's an administration, it has to be the release and funding bond has to be filed with the surrogate. Otherwise, the administrator continues to be liable and has to pay this bonding fee for every year.
Yes.
And, we sometimes find people say, well, nobody told us that. I goes, no, you represented yourself. It's like the doctor never told you about something you didn't tell them about. So, one of the things you're hiring with some of the attorneys is someone that has a little bit of smarts and can kind of guide you and make it sometimes quicker, faster, and less aggravating. Let's see. All right. Thank you. Heather, anything else you want to say about the probate process?
Just if it ever gets to the point where there has to be a formal accounting, the surrogate is entitled to an audit fee. So, I mean, that's just more money being taken out of the estate that's not going to be distributed to the beneficiaries. So,
And by the way, how much is that?
There is a statute. I'll send it
Yeah.
to you tomorrow, but it's pretty hefty.
Yeah.
Because we charge by how many pages. It's $5 a page for the accounting, however many pages it is, and then there's an actual statutory fee, which I'm sorry right now off the top of my head.
I don't know at the top of it, but it's a percentage. So if it's
It's a percentage.
$200,000, if it's $500,000, if they're selling a simple house and some other stuff, then you could be spending like 10, 15 grand
Yep.
plus the delay in time in getting your stuff.
Exactly.
Yeah.
Exactly. But that's all I have to say. And if anybody ever needs anything or has any questions, please reach out to me. My name is Heather Antonuccio. You can reach me at the surrogate's office. So please, I will be happy to help with anything anyone ever has any questions with, or if anyone needs anything from our office.
Right. One of the things I always tell people, I go, listen, calling the surrogate's office, they're nice people because that's their job to be nice. Because someone passed away, the surrogate also does guardianships of disabled adults and other things. So that's their job to be nice. Let's say, if you call motor vehicles or some government entity, they're less nice. if anyone picks up at all. Very good. Okay. Dave Selenko, are you ready to tell people what's a good idea on how not to screw up your finances?
Yes, I am all ready. Thank you, Ken. Very informative, both of you. It was great. Just want to do this briefly so that we get on as on time as possible. My name is David Selenko. I am a financial advisor with the SWR Group in Island, New Jersey. Also have an office in Hamilton. What I'm going to speak on here tonight is just 10 areas for people to focus on, just to concern themselves with. I think the first 3/4 of this has to do more with people who are close to retirement or in retirement. The last quarter of this will be basically for everybody. So let's get started here. Number one, for people, especially as you're getting close to retirement or in retirement, is hold and make sure you be careful about holding too many risky assets too close to retirement or in retirement. Now, I'm not suggesting not investing in stocks, things of that nature, but this day and age with so many stocks that are being touted online, on the internet, people are going crazy with some of these things. And whether you do your own homework on your investing or you have a financial advisor or you talk to your family about it, is just be conscious of not taking too much risk. Right now, bonds are not creating the income that our grandparents, great-grandparents would get in bond returns at 4%. So people are looking for ways to get a return. But I would just be careful not to go too aggressive. Try to get income, try to get things like dividend-paying stocks, things of that nature. And I would talk to whoever you lean on when it comes to these things. Another very important thing is to make sure that you do a cash flow analysis. Know what your expenses are. Know your budget. This goes for anybody at any age. Is know what your expenses are. It's very, very important. Obviously, if you're in your earning years and you're saving and things of that nature, knowing what your bills are, your mortgage, things of that nature. Once you hit retirement, there's really three areas that I'll quote is what the go-go years, where people are in early retirement, they want to travel, things of that nature for, let's say, 5 or 10 years, they're able to do it. Then there's the slow-go years where you're slowing down, you don't want to do as much, but you still want to do a few things. And then there's what's called the no-go years, where you're getting into your later time. You have to know what the expenses are, because if you're retired and you're not getting income from a job, where are you getting this income from? Social Security. If you're lucky enough to have a pension is great. 401k, IRA, 403b. However, certain expenses do go up. I mean, you're very likely housing expenses for most people will continue to be one of the main items when it comes to their budget, but also then they have to worry about healthcare. And that's a big, big area. We'll get into that in a moment. Number 3 is to make sure that you file for Medicare on time. If you're retired at age 65, make sure you are filing for Medicare. If you're still working, it's not required right away, but once you retire, again, file for Medicare, because if you're late for the parts that you have to pay for, if you're late for filing, you might have to pay a penalty, very likely will have to pay a penalty when it comes to the parts where you're paying for Medicare, and you don't want to have that happen. So 65 years old, if you're retired, or a few months prior to age 65 or a few months after age 65, or if you're still working upon retirement. We were just talking about medical costs. And obviously, when we talked about Medicare, there are parts of Medicare you'll have to pay for. Part B, Part D, dental, vision. And obviously, there's something called a Medicare supplement that will give you the opportunity to cover those expenses, but that's a cost out of your pocket to pay for the supplement to cover any residual costs that Medicare will not pay for. So you have to be concerned about that. We'll talk a little later about long-term care, and for a certain percentage of the population, there will be a need of some sort of long-term care, whether it's at home, in assisted living, or if need be, in a skilled nursing facility. Another question, big question for retirees is when to start Social Security. The vast majority of people start at the age of 62. I paid into it. I want to get the money out as early as possible. Well, for some people that makes sense, especially if you really need the money. For other people, the longer you wait from the age of 62 to the age of 70, the amount that you'll get paid out will go up by 8% simple interest, but it will go up by 8% each year. And if you're thinking about waiting for a later period of time when it comes to Social Security, you need to know most important things. 2 things is obviously if you can pay for, if you have your expenses paid for and don't need Social Security, your own health and your family history when it comes to health. If you have longevity in your family and also your health has been good, it may make sense to think about waiting and taking Social Security later on. For others, if your health isn't so great or your family history is not great when it comes to longevity, you probably want to start taking Social Security earlier. For people that have qualified retirement plans, 401k, 403b, IRA, the time that you have to start taking money out, called required minimum distributions, that's now the age of 72 years old. So starting at age 72, if you haven't started already, that's when you'll have to start taking money out of your retirement plans. If you don't take money out or you don't take a portion out, there is the potential for you to be penalized 50% of what you don't take out. So if you were supposed to take 1,000 out and you don't take it out, and the IRS catches up with you, then the problem becomes is you may have to pay $500 on a portion that you never took out because you've been penalized for not taking it out. So it's something very important to make sure that you remind yourself at age 72 to start taking minimum distributions. For certain people, I'll call them the luckier folks who may feel like they may not have to tap into their 401k or IRA or other qualified retirement plans. For those people, they may want to consider converting those particular assets into a Roth IRA. And for those people who've heard of this, who have not heard of this, the Roth is after-tax money. And what the Roth IRA and now Roth 401ks allow is you put money in after taxes, that money and any growth is not taxed later on. And if you feel that in your before tax money, your traditional 401k, your traditional IRA, if you're not going to need that, it may make sense to convert that to a Roth IRA so that if you may never use it, you may want to pass it on to your beneficiaries who will be able to benefit from the Roth IRA, and they won't have to pay taxes on. So something to think about. I mentioned earlier, and this is a question I ask, is are you financially equipped to handle the cost of care for assisted living, at-home care, long-term care? Folks, if there's one thing to know living in the Northeast, the average cost annually for being in a long-term care facility exceeds $100,000 a year for skilled nursing and things of that nature. So it's something to keep in mind is, have I prepared for this? You know, you may have saved very well, but if all of a sudden you or your spouse have to go into a long-term care facility, that's a lot of money coming out of pocket. And if it's in qualified plans, to pay taxes on that. Very unfortunate, very, very hard. The other side of it is some people may be taken care of at home. It may not be a financial cost, but there's an emotional and mental cost to your caretakers if it happens to be family or friends. So something to think about, long-term care. For the people who are still in the workforce, is make sure you're saving for retirement. I don't care what age you're at. If you have the ability to put aside money, if your company or if you're a public worker putting aside money in a 401k or a 403b, 457 plan. For those of you maybe saving less, an IRA, but make sure you're saving so that you can help with yourself with growth on that money. And also, if it's before tax money, you potentially are reducing your gross income on your taxes. So that could reduce slightly. Maybe if you're putting aside enough, you potentially could be putting yourself into a lower tax bracket. Doesn't always happen, but there's that potential. If you have children, are you setting aside money for college and or grad school? 529 plans, things of that nature, or if you have the wherewithal, if you want to pay money directly to the institution for the benefit of a grandchild or a child, you can do that. But saving money for education. A big thing for people who are still in the workforce is, are you set up financially if you or your spouse become disabled? It could be short-term, it could be long-term, but the issue becomes is if you as the breadwinner, either of you as breadwinners, all of a sudden become disabled, are you able to pay the mortgage, utilities, groceries, things of that nature? So I know some of you may, through work, may have disability insurance through your company. For those of you who don't, you might want to look into something that protects you in the private market with a financial advisor, with an insurance agent, to make sure that you're protected should disability befall you. And the last thing I want to get into, and we'll finish this, and I like to finish this up all the time, where this comes back to what Ken was talking about, is what is the financial impact of not creating or updating your will and not changing beneficiaries on retirement assets, life insurance, and annuities? Ken was getting into it, and there's really a pattern here for in your lives. For those young couples who have a young child, you need guardianship. You want to make sure you trust somebody. Should both of you not be around, who's going to be around to raise that child? Who do you trust to raise that child? God forbid you shouldn't be around. Then mentioned earlier about teenage children. My kids are 20 and 18. They're both in college. Something happens to my wife and I don't think I would trust them by just giving them outright my assets. So what do? You need to talk to someone like Ken, is what can be put into the will to protect against the children spending down the entire estate. Another one is your children who are married. And I try to be funny when I say this, but it's really not, because the percentage of people that do get divorced in our society is the fact that I call them the future ex-spouse of your children. If you leave assets to your children outright, and then the child takes the money and puts it into accounts and what's called commingling with their spouse, and then they get divorced, that spouse could end up with potentially 50% or more of the assets that were earmarked for the child. So again, talk to someone like Ken, who can put something in a document that protects your assets just for the benefit of your child, so that they don't get commingled with the quote unquote future ex-spouse. There may be a few of you out there or more who have been married more than once. If you have children from a prior marriage, but you're married now to someone else, how do I handle something happens to me, leaving assets for my spouse, but also wanting to leave assets for the children from the prior marriage? Again, speak with Ken about how you set that up to make sure that your assets are protected how you want them distributed. And then finally, was talking about beneficiaries on retirement plans, life insurance, and annuities. Is, if there are changes along the way, you don't only just want to change your wills and other documents to change the beneficiaries or change executors, people like that, because things change, but also who are the beneficiaries on those particular investments, like I mentioned. If you don't change those things and then you pass away or someone predeceases you, if you don't leave another beneficiary, there's the potential that those assets could go into what we talked about earlier, probate. And all of a sudden, those assets may not, who knows who they're going to go to, if there are family members. I had one situation where a son predeceased the father. Father never changed the annuity, the beneficiary on the annuity, and then he passed away in the last couple of years, and there was nobody named, there was no will for the assets to go through, and all of a sudden it was what looked like a free-for-all, and then we had to go through the probate process, and what descendants were out there, nieces, nephews, whomever, how are they going to get this and at what percentage? And each individual who was beneficiary wanted to be named the person who was going to take care of the administrator of the estate, and that was a problem. So thank you for your time. I know I went through this pretty quickly. Thank you for giving me the extra time here. I hope you got something out of it. What I would like to do is I'm just going to put my information on the side here. If anybody needs to reach out to me for any reason, please feel free to reach out to me. But thank you so much for your time. Joy, thank you for putting this together. Heather and Ken, great job. And I look forward to seeing you guys down the road.
Dave, there's a couple questions. So there's one in the chat box. You're going to do that, and I'm going to look at some of the other questions real fast. Okay. So question number one, what information do you need to have before you begin talking to the lawyer? I don't need to know substantial details about assets, really just where do you have your real estate? Because for the purpose of federal government now, the federal state tax is $11.7 million, and not too many people I know have 11.7. Should I make my condo part of a trust? I tell people in New Jersey, you don't need to spend money on a trust. After someone passes, we email out a probate questionnaire, some of the questions that are on the inheritance tax, and then I have people sit in the office and I go over how we can do things. I mentioned about the irrevocable trust, that protects assets after 5 years from Medicaid. But I'm not sure about the amount of income, but it's a very, very small amount. And I don't do Medicaid planning just because the law changes all of this. Let's say, how many years have I been doing this? I've been doing this for, I look young, but I've been doing this now for since 1985. And I wrote a book for the American Bar, and I do the book for the New Jersey State Bar when they have their probate thing. So, this is what I do. If someone asks me questions about the child support issues nowadays, I go, I don't know about that. Now, Dave, there was a question in the chat button dealing with someone working at 72. Yes. What's the answer?
So Dr. Robinson, the answer to that question is if you are saving into an employer plan, you do not have to take minimum distributions until you retire from the employer plan. But if you have other IRAs and things of that nature, you are required to take minimum distributions from those that are not part of your employment or your own business that you own, whatever it might be. So that's the fine line there. So if you're saving through work, you don't have to take minimum distributions through that plan, not until you retire.
Very good. All right. I think we're done for tonight. Thank you, everyone. Be well. And it's November, so I guess Ms. Robinson will see everyone again sometime in March. Thank you. Have a good evening. Dinner time. Bye-bye.
Thank you, everyone. Thank you, Ken. Thank you, Heather. Thank you, Dave. Take care, everyone. Enjoy your holidays.